Hello and welcome to another episode of Can You Talk Real Quick? This is where I reach out to a very expert guest on a very important and impactful issue and interview them, get it turned around quickly for you to listen to, digest, and understand how it impacts you, your family, community, country, or the planet. Today, it's our good friend, Professor Eric Segall of Georgia State University, the host of the Supreme Myths podcast, constitutional law scholar, has written two very important books, Originalism is Faith, and, of course, Supreme Myths, always held that the court is not a court, the justices are not judges. More proof of that today. We talked about three specific cases the court decided here at the end of their term in June, end of June 2023. We talked first about the affirmative action case. Then we talked about a case affecting LGBT hiring or firing. And finally, we discussed the affirmative action case. So without further ado, because that's what I do with Can You Talk Real Quick, get there to you real quick, very little production, turn it around, get it posted for you to listen to. We actually went live on Twitter for this as well. So follow him at Eastman Segall. I'm, of course, Pete Dominick, and I can't do it without your support. So please consider a subscription, patreon.com/Pete Dominick, so we can keep doing this kind of really enlightening, informative, and sometimes, maybe not today, but inspiring content. Let's do it. Eric Segall, can you talk real quick? Starting with college zone forgiveness case.
Yeah, I mean, I read the syllabus. I mean, it's a really long opinion. We knew what it was going to say, and it says exactly what I think we thought it was going to say, which is the statute that created the student loan program, despite having an exception for a clause allowing for student loans to be deferred or wiped out in emergencies. The court said that the Biden administration went too far in forgiving student loans. I can't say it better than Elena Kagan, who said, and Justice Kagan begins, and she's not, this is a pretty angry dissent for her. I don't blame her. By the way, Justice Barrett wrote a long concurrence about the, quote, major questions doctrine, and that concurrence is terrible. So I have skimmed that concurrence, and it makes no sense. All right, Justice Kagan. In every respect, comma, the court today exceeds its proper limited role in our nation's governance. In every respect, the court exceeds its limited role in our nation. And that's the story of the Roberts Court. And you don't have to believe me. You can believe a non-con law professor at Stanford who dabbles in con law, but has been following all of this over the last 3 to 5 years and wrote a big article for Harvard called The Imperial Judiciary. And that's what this is. This is the Supreme Court usurping the powers of Congress and the administrative branch. When Congress wrote the student loan program, it had an emergency out. Almost, Pete, since there were sheep in the fields, since common law began in the 1300s or wherever, there's always been, quote, a necessity exception to the law. I don't have a right to kill you. If you break into my house with a gun, self-defense is kind of like necessity, right? There's always a necessity exception. And that's kind of what Congress was getting at here. These student loans have to be paid back unless some kind of terrible emergency thing happens. And guess what? COVID happened. And it was an emergency. And we're still not seeing the effects of this emergency on children, on college students, on graduate students, on the economy. It is still very much up in the air, and it's complicated. I don't know if, as a policy matter, President Biden's decision was the best decision for the interests of the United States of America. I don't know because I'm not an expert in the economics of student loan programs. Here's what I know. We elected Congress and we elected the president to make those decisions. None of us elected the Supreme Court, and none of us thought they would displace the economic decisions of the elected branches with their own bizarre view of the relationship between the powers of Congress and the powers of president. Now, theoretically, Congress can change this, and I hope they do. I mean, Congress can tomorrow legislate with specificity, saying President Biden is allowed to forgive student loans because of the COVID emergency. There's no constitutional problem with that. The problem is the filibuster.
Right, of course, and they won't. They would. Yeah, right. Really important points about in Kagan's dissent there. In every respect, the court has inappropriately decided this. I'm paraphrasing, obviously, what you just wrote, and you've been writing this for years. But the judicial branch, in this case, you said the administrative branch overruled the executive branch. That's what happened.
Yes, okay. and really, again, I haven't read the opinion, but I read all the briefs and I skimmed the opinion. And it's just the court substituting its judgment for that of the president and the Congress. Let's go to 303 Creative.
I will, but just real quick, Chris Hayes tweets, lots of very bad things this 6-3 majority has done, Dobbs being, in my opinion, the worst. But them deciding you're now $10,000 poorer than you were yesterday is really a hell of a thing. Do you agree with that characterization?
Yes.
Okay, let's get to 303 Creative. This case was also, we got the results of this case today. The Supreme Court decided against gay rights in a case that didn't involve apparently any gay people, we just learned, and against debt forgiveness in a case where the lenders were fine with the issue, by the way. They're not acting like judges. They're acting like an unelected super legislature that can't be checked. That's somebody on Twitter that I just read. Of course, you've been saying that for years. But let's get to 303 Creative and the Supreme Court decision on gay rights and how they're affected.
So Sotomayor dissents in this case and begins by saying, basically, and I think this is a little bit of an overstatement, but the idea is correct. For the first time in American history, the Supreme Court allows a commercial group to exclude a protected class from its services. That's not exactly right, because we had discrimination against blacks forever. But here's the thing about this case. So the woman who's the center of this case, we now know, never received a request to design a website for a same-sex wedding. She made up the facts. Case should end there. The Supreme Court should have said, you know what? Bring us a real case. This is a fake case. Now, there's a little more subtlety to that. Pete, if I want to do something that I think is illegal and Georgia law makes it illegal, and I am ready, willing, and able to do it, I have the money, I have the license, I have the space, I just want to open this particular store. And I know under Georgia law, I may get arrested or fined if I do it. And I write a letter to Georgia, the state of Georgia, the Department of who's he was. And I say, I'm planning on opening this business on June 3rd. I have the money to do it, but I think you're going to arrest me if I do so. Could you please give me some information? And they write back and say, yes, if you open that business, we're going to arrest you. There's nothing wrong with the court hearing that case, with me bringing a case saying, I'm ready, willing, and able to open this business, but I'm a law-abiding citizen. Georgia tells me it's illegal, so I want a court to tell me it's not first. That's called the Declaratory Judgment Act. It's been going on since 1934, and it's fine. The difference is between my hypothetical and 303 Creative is I was ready, willing, and able to do it. I had the money, the license, and everything else. She has not proven any gay couple is ever going to ask her to design a wedding site for them. So the court should never have decided this case. Now, as I've said to your audience before, Pete, and it pains me to say this, this is not a religion case. Religion has nothing to do with it, and religion objections to anti-discrimination laws, in my opinion, are bogus and frivolous and should not be taken seriously by any court. This case is harder because let's take Billy Joel, who I believe played at Rush Limbaugh's wedding to my great chagrin. To my great chagrin. But I believe he did. If Billy Joel is asked again today to play at Rush Limbaugh, well, he's dead, but to play at some conservative's wedding, my guess is he would say no because he has evolved. The state can't make Billy Joel, because he did some weddings, sing a song at somebody else's wedding he doesn't want to sing. That's creative. That's the First Amendment. And I think in a proper case, someone who is asked to design a custom website for a same-sex wedding or a heterosexual wedding or an interracial wedding, it doesn't matter. And if they say, I don't want to do that design for this customer, I think the First Amendment probably protects that as a matter of law. I think it's close. I think it's a close case. But that's not what I want to talk about, because that's just lawyers arguing about text. What I want to tell you is I am so fucking sick and tired of Christians saying we hate homosexuals, because that's what they're saying here. That is what this woman is saying. Now, Gorsuch says, she says, no, I like homosexuals. I just want to see them get married. That's the fucking same thing. Because if you can't get married, you lose money, you lose rights, you lose privileges. It's second-class citizenship. So this woman is saying, as a matter of my faith, these people are second-class citizens. Well, you know what? Her faith sucks. And if it's not her faith making her do it, then she sucks. And just substitute the words interracial marriage, and it will be clear. I don't want to design websites for interracial marriages, and the entire internet is going, you're a bigot. I don't want to do wedding sites for same-sex marriages. Same thing. You're a fucking bigot. And the court, and because the court didn't have to decide the case because of this whole standing issue. Now, when it comes to standing, the court can do whatever it wants, anytime it wants, and it's totally discretionary. but there was she wasn't fined. She wasn't put in jail. She had so far suffered no punishment. So there's no reason to decide this case. The reason they did, and by the way, the conservatives of the 1980s, the Justice Rehnquists, the Justice O'Connors, even Justice Scalia's, used to say, if we can avoid deciding constitutional questions, we should. Well, the court had a very easy way of avoiding this constitutional question, which, by the way, even the most strident LGBTQ supporters, I think, would say it's not the easiest case. It's not. I mean, we have free speech versus gay rights, and it's legitimate. It's tough. It's difficult. So why decide the case at all? She wasn't hurt. She wasn't punished. It's just awful.
All right.
But the real point I want to make is this woman might have, the Nazis had every right to march in Skokie. They did. They had a right to march. And as long as it was nonviolent. And we have the right to say what they're marching for is pernicious, evil, terrible, and immoral. This woman might have the right to refuse to do this website if anybody ever asks her to do it, which no one has yet. She might have that right, but it's still terrible, awful, bigoted. And to do it in the name of Christianity, I had so many people in my Twitter feed this morning saying this has nothing to do with Christianity and we shouldn't pretend that it does. And I agree with that.
Let's talk about something else you could probably put religion into. Yesterday's case, decision on affirmative action for college admissions. We've talked about this plenty of times before. We've done deep dives in it. I'll talk with Tim Wise about what this means, the policy outcomes, what it means for actual lives. But you had a lot to say on Twitter and everywhere else that you've been about the decision here. And you know who else apparently did? The liberal justices, specifically Sotomayor and Ketanji Brown Jackson, in their dissents were pretty brutal. I think it's fair to say.
Well, that's because Pete, as a policy matter, affirmative action is complicated, and we never actually have done this because I've served on admissions committees, because I've served on faculty hiring committees. I have had to struggle with these issues personally for 30 years. And I will tell you, I'm in favor of affirmative action, but I understand the arguments against it. I do. And I think we could have a reasonable debate about that. Here's what we can't reasonably debate. The Constitution does not preclude. Not the text, not the history, not the original meaning, not the traditions. There is color blindness, as I said on Twitter, living constitutionalism on steroids. And Pete, I want to make a big point here, separate from affirmative action. It is one thing for Justices Brennan, Marshall, Kagan, Sotomayor, the liberals, to issue living constitutionalism cases because they own that most of the time. They talk about the policy and they own it. It is quite another thing for four so-called originals to adopt what is nothing more and nothing less than Warren Court living constitutionalism. The hypocrisy. And you know what? If they were elected officials, they wouldn't get away with it. They wouldn't. I know we let our elected officials get away with a lot, but when George Bush was on his way, the first, George
H.W.
H.W. Bush, who I worked for, I should know his name, was on the way to winning when he said, read my lips, no new taxes. And then he raised taxes, and the hypocrisy got Bill Clinton elected.
Yeah, that's a good example.
If these government officials we call judges but who aren't were elected, they would be out in a minute based on the hypocrisy between what they say is their technique, originalism, and what they actually do, which is a form of living constitutionalism that is even greater than the Warren Courts and is much more hypocritical.
Did they not cite the 14th Amendment?
No state shall deny to any person the equal protection of the laws. No person was denied the equal protection of the laws by Harvard or the University of North Carolina at Chapel Hill. Both of the schools that lost. Both schools look at all of their tens of thousands of applicants and make individualized determinations based on a whole bunch of factors. And the only reason race is used by either Chapel Hill or Harvard or the other thousand universities that do it is to increase racial desegregation, to increase diversity, to get more different, more people of color, whites, blacks, Hispanics, brown, yellow, green, gray, purple, whatever, in the university. The 14th Amendment says nothing about that, Pete. What the 14th Amendment was designed to do was basically assure blacks they would have equal rights. It was written broader than that. But there, first of all, there's not even a law here. The 14th Amendment requires that no state shall deny to any person the equal protection of the laws. The University of North Carolina Admissions Committee is not making a law.
Right.
It's making a decision based on a whole bunch of factors. And it's not. And by the way, Chapel Hill is 8% black, and North Carolina is like 20 is double that in terms of its black population. So I wrote a piece for Dorf on Law a few months ago. This isn't even intentional discrimination. The Supreme Court has said, when blacks are hurt, the Supreme Court has said, you have to prove intentional discrimination, that somebody was out to get black people because they are black. That's what the court said. And that's what blacks have to prove. That's what Hispanics have to prove. That's what Asians have to prove. No one here was trying to hurt white people. This was not an intentional choice to hurt white people. This was an intentional choice to diversify our nation's campuses. The 14th Amendment, its history and its text, does not speak to it at all.
Hurts me if I had better grades than the black guy and he got admitted.
That's not how universities work. I can tell you this firsthand knowledge. So we once had at Georgia State, we had a Orthodox Jewish person from Tampa whose LSATs, the law school tests, and grade point average were well below our medians. She wouldn't have gotten in based on just her grades and LSATs. Her personal essay, Pete, had a heart-wrenching story about anti-Semitic riots in Tampa in the 1980s, I think it was, where her parents' business was burned down and they lost everything by anti-Semites. And the essay was so powerful. And she explained how she lost years of schooling by having to help her parents rebuild the store, that we took her. And that is not uncommon. Harvard has more than enough perfect GPAs and perfect test scores. They go with other things, like, are you a good violinist? Did you grow up in rural Nebraska where you're the first person to go to college from your family?
Yet colleges did not consider my essay, which is the real pain, that playing time only in what was called the fifth quarter for the not great athletes. What that did to me, I still get surpassed by people of color in admission.
I'm not sure what you're saying there.
I'm saying that was an amazing essay, but they didn't see my apparently struggle.
Well, so you and I talked before about not going back to the legal stuff. Did they end affirmative action forever? Well, it's hard to say. We're actually not sure.
Well, Michael Harriot, I want to get to that, but you tweeted Michael Harriot. I love this. He says, before you begin your think piece, the Supreme Court did not strike down affirmative action. Admission preferences for legacies, donors, employee families, and special recommendations are still allowed. The court struck down affirmative action for everyone except white people. I mean, it's a broad generalization. You could argue rich people, I suppose, but still.
No, he's right, because legacies are at Ivy League schools, legacies are almost all white.
Almost always, yeah, but they could be. The point is, it's wealth. It's guaranteed it's wealth. It's inherited wealth.
Right. No, I mean, what Justice Thomas would say in response to that point, playing both sides, is he would say, but the 14th Amendment doesn't talk or doesn't mean anything about athletics or legacies or donors or whatever. It only talks about race, except the problem is the 14th Amendment doesn't mention race. So when Justice Thomas says that, he's just making shit up. In any event, I do think that at the very end, this for your audience, at the very end, Roberts says something to the effect of course, students can still write an essay explaining how they overcame obstacles because of their race. And I guess universities are allowed to look at that. But what that means on the ground in practice is anybody's guess. But the unanimous view that I've seen so far among legal experts is it will lead to, again, much more litigation. The court should have done something that Justice Scalia wanted the court to do with abortion 40 years ago, which is the court should have announced today, we are out of this business. If universities want to improve their diversity by taking into account race, the way they've been doing for 30, 40, 50 years, and as we've allowed them to do for 30 or 40, 50 years, if they want to do it, fine. They don't have to do it. And by the way, Pete, the most important point here is if the people don't like this, they can change it. In 10 states, people voted to outlaw affirmative action. Why do we need judges to protect the interests of white people, basically, who have all the recourse they need to the polls? One of the original justifications for a strong Supreme Court is to protect minority groups who don't have access to the polls, the same way whites do. boy, has the Roberts Court turned that on its head, right? And at every step, the Roberts Court has inverted that proposition and is protecting white people who lose at the polls, not people of color who lose at the polls. And that may be the saddest thing.
To wrap it up, you tweeted yesterday, abortion, guns, affirmative action, administrative law, church and state. This court has dramatically changed the law related to these topics in just a few years. If changing judges changes law, do we know what law is? Also, if SCOTUS doesn't take its precedent seriously, why should we? You've made this previous point, and I get it, and I obviously agree with it. How can I argue with you? But when you say, why should we take precedent seriously, what do you mean?
So I wrote a piece a few months ago that if the Supreme Court strikes down the student loan program, Joe Biden should say, pardon my language, fuck you. I'm not going to collect the loans. What are you going to do? You have no army. You have no guns. You can send the marshals after me, but I'll send the nukes after you. I'm going to win that battle. If I were Biden, I would not comply. Of course, this is not Biden's way. Now, the response to me when I say things like that is people will go, hold on, Segall, 1957, the governor of Alabama says he's not, of Arkansas, says he's not going to desegregate the schools. And President Eisenhower sends in the National Guard. Okay, that's not the fucking same thing. That's a moral principle of equality that the president should absolutely ensure. The president's job to uphold the Constitution. Arkansas was violating the Constitution by saying blacks have to go to separate schools. Of course, the president should send in the National Guard.
So much
what exact principle does the student loan case today kind of stand for? That the court gets to decide what is the proper lawmaking during a COVID emergency when it comes to student loans? No, the president should say, I get to decide that. That's my job. And Congress, because Congress gave me the power to do it. Congress didn't give him the power. Now, the court would say Congress did not give you the power to do it. But Congress did. It's right there in black and white. In emergencies, you can forgive the loans. So they did. So, Pete, I am tired. I am angry. I'm going to write a long blog post for Mike Dorff next week on Dorff on Law called Supreme Hubris. But the theme of it is not going to be new. It's going to be in 1857, when the court said Congress could not end slavery in the territories, when the court said Congress couldn't end segregation in 1883, even though it tried, when the court struck down 200 laws between 1900 and 1936, dealing with minimum wages, overtime, child labor. Congress tried to end child labor. The court said it could not do that. When the court basically ended state desegregation efforts in parents involved, with Justice Roberts uttering the famous line, the way to stop discrimination on race is to stop discriminating based on race. Nobody was discriminating based on race in Louisville, Kentucky, when parents and teachers got together and voters and decided that this state has been segregated for centuries. And so we're going to add a little more diversity to our public schools. And the court says, no, you can't do that. Why not? Because we said so, which is not a good reason. The court is once again entering a thicket where it has for the last 10 years, where it simply does not belong. When are Americans going to learn? I don't know.
Worth mentioning, your predictions have been pretty right on for years, sadly. I know you didn't want them to be. And I just do want to mention and apologize to everybody watching. You know, we went live here on Twitter, and you definitely used a saltier language than you do even on tape. So I feel like we should have warned people that you were going to be so filthy. I'm offended.
Sorry, because I'm really tired. And I think most liberals watching the court are really tired. And Pete, it's not just because liberals are losing. And there's always going to be a back and forth in this kind of thing. It's Justice Gorsuch today in the 303 creative case really insults Justice Sonia Sotomayor, saying that she totally got the facts wrong of the case. Leaving aside that Sotomayor's version of the facts is accurate and Gorsuch's is not. Leaving that aside, for Neil Gorsuch to criticize any other justice for playing hard and loose with the facts after he said that a football coach prayed by himself at the 50-yard line when the dissent put pictures of the football coach praying with students on 3 separate occasions. Yeah. For him to criticize, that's what I'm talking about. I'm not tired by losing. I'm tired by the inhumane hypocrisy of these FedSoc judges.
And I feel like people, whoever said it this way, it's like, I'm tired of the fact that they're not making good legal arguments. They're glorified right-wing bloggers in their legal. So years ago, I wrote a piece about Justice Thomas's results, not his reasoning, just his results. Mm-hmm. And it's like 2 paragraphs long of the most important con law cases of the last 40 years, whether it's affirmative action, whether it's Obamacare, whether it's abortion, whether it's term limits on members of Congress. People forgot about that issue from the 1990s, whether it's separation of powers. And every result he reaches is simply consistent with GOP priorities. They are simply Republican political. Right. Yep.
It's what they are.
Proven over and over. All right, well, get to all the other work that you have to do to recap this. Let's wrap it up so I can post this on the podcast, Stand Up with Pete Dominic. If you're not following, do, and listen to Eric's podcast, Supreme Myths. Get his books, if you haven't already. So good, and unfortunately so prescient. I would tell them to follow you on Twitter, but that's where they are right now if they're watching. Thank you, my friend.
Thank you, my friend.
All right. All right, there he goes, Eric Segall. Go thank him at eSpin Segall on Twitter. Go listen to his podcast, get his books. That's it for this edition of Can You Talk Real Quick? Thank you very much for listening, for supporting, for writing a rating and a review on Spotify or Apple or wherever you are. Be present, do what you can to create positive change, and I'll be right here along with you for the ride. Thanks for listening.